Thank you. Thank you so much for inviting me. Happy to be a part of these seminar series. Um, I'm Deepika Kinhal. I lead the judicial reforms team at Vidhi Center for Legal Policy. We call ourselves the Jaldi Mission, Justice, Access and Lowering Delays in India mission. We undertake independent research projects. We also engage with the judiciary at all its levels. And we work with experts from all kinds of domains to collaboratively arrive at solutions, which we then take to the judiciary. So, this is the scope of our work. Today, what I'm going to be talking about is part of our working paper series. It is an independent project that we began early this year. We have published one working paper so far, and the second one should be out today. In fact, I don't know if it is up on the website yet, but it was in that process the last I saw. I'll be taking bits and portions of these two working papers and presenting before you all, and it is very much as the name suggests, a work in progress. So I'm really looking forward to receiving inputs on the ideas that I will present before all of you today. Okay, so the topic is differentiated case management system in Indian courts. I would like to begin by spending a few seconds just reading this paragraph, which is an extract from Lord Wolf Committee report. It was published in 1996 and formed a precursor to the amendments that were brought to the Civil Procedure Code in UK. Quoting, dealing with a case justly includes, so far as is practicable, ensuring that the parties are on an equal footing, saving expense, dealing with the case in ways which are proportionate to the amount of money involved, to the importance of the case, to the complexity of the issues, to the financial position of each party, ensuring that it is dealt with expeditiously and fairly, and allotting to it an appropriate share of the court's resources while taking into account the need to allot resources to other cases. So it is point C and E that we are going to be delving into today and seeing how that can be made applicable in Indian context. So what is differentiated case management system? Right? At the heart of it, it is a management system, which means that we need policies, processes, and procedures designed towards achieving of an objective that the system identifies. So it is a management system. Now, what is differentiated case management system? At the heart of it, it comes from an understanding that cases vary in their requirements, complexities, and trajectory, and therefore should not be treated alike. And once you determine what these differentiating factors are, you segregate the cases. And then the second level of mindset change required is that you recognize that judicial resources are limited and choose to allocate judicial resources as per the specific needs of cases. So you optimize judicial resources, especially time, judicial time. And then you tailor your policies, your processes, and your procedures in the court system to ensure that your objective, which is optimal utilization of judicial time as per the needs of a case, are met. So this is at the heart of it what differentiated case management system is. Fairly straightforward, right? And it is intuitive, it is practical. But what is the current scenario in our courts? How is judicial time allocated to a case? While I was drafting this slide, I was wondering what I should title it. Current framework, current system, current set of rules, and then I realized none of this actually exists. So it is current scenario. We don't have a system at the moment which determines how much judicial time is to be allocated. And by judicial time, I'm talking about minutes and hours and not days, right? Usually it is confused with the time taken for disposal of a case, and that is calculated in terms of the difference between the date of filing and the date of disposal. But that is not the judicial time spent. That is the time a case spends in the system. But judicial time spent is how much of a judge's time is being dedicated towards that particular case in a court. not even in the administrative side. In a court, while applying judicial mind, how many minutes are ticking? So how is that currently being determined? It is not being predetermined at all. It is entirely ad hoc, and it is almost entirely driven by advocates. And one would hope that those advocates are being driven by their litigants' concerns, although we do know that that is often not the case, right? The other factor which determines how much judicial time is being spent in the recent years is what is known as ACRs. There are these annual confidential reports which determine the performance levels of district judiciary judicial officers. They have a point-based system which gives um, uh, different criteria, and different sets of points are allocated based on the criteria. Sometimes judicial officers are determined, are driven by what the ACR allocation framework is, to see how they prioritize the cases. And that also then plays into how much time they give to each case in a court. The other determining factor is statutory limits. We do know that there are special legislations now apart from CPC and CRPC which set an outer time limit, saying, dispose this case within 2 years, dispose this case within 6 months, and that sort of has an influence on how often a case gets listed and how much time is allocated at specific stages. However, we do know that all these statutory time limits are mostly followed in breach. Then there was this other creature called case flow management rules, which miserably failed, although the intent was right, that we bring in some level of streamlining in the way cases are managed, and also vest some control with the court in terms of how cases flow within the system. However, given that the metrics or the parameters that they set were so unscientific, again, it was followed more in breach. So right now it is mostly the advocates driving the system, and it is mostly the chief justice and principal district judge, chief justice at the high court level and principal district judge at the district court level, who determines how cases need to be dealt with, what kinds of cases will be expedited. Here mostly it is extremely delayed cases that come into prominence, or cases which are of high value, and again mostly politically sensitive cases, cases which are in the media, which get taken up on priority basis. So overall, the way the extent of judicial time is spent on a case is unscientific. There is no data-driven allocation of time as such, and it is unfair. At the heart of it, it is unfair because it is driven by lawyers, and it also does not take into account the needs of other litigants. So it is me who is there as a lawyer, and I will take how much ever time I want, because either I will get paid based on hourly rates, or my litigant, my client is waiting over there to see what impression I make on the judge. So nothing is really, bounded by any set of data or rules, and and hence the need for DCM. But DCM is not a very straightforward framework that you can just adopt from some other jurisdiction, or you can just adopt into the system on an ad hoc basis. It needs to be a deeply thought out framework for it to work properly, and it has to be entirely data driven for the parties to buy into the system. And what do we currently have in terms of data to start out in terms of designing a DCM for India? What we know, thanks to e-courts and NJDG, is the historical average number of days for disposal. And we also know the number of times a case gets listed at each stage. However, what we need is actual judicial time spent through the life cycle of a case. Is a writ petition taking 6 hours of a high court judge's time? Is a property dispute taking 100 hours of the judge's time? We need to calculate that, and we need to calculate that by being there on ground as researchers, or we have this engagement with a court where the court invests time or frames policies to calculate this. But this forms the foundation of any DCM system. What we also need is parameters to assess complexity, right? So once we have the judicial time, we also need to then segregate cases not just based on how much time is historically being spent, but also in terms of the nature of the case, the requirements of the case, and this is where legal assessment will become important. Now, given that we do not have data for what we actually need across cases in the High Court and the District Court level, we have started out with constitution bench cases. Our working paper 1 on DCM focuses on constitution bench cases. Why? Because now we have records of live stream proceedings, we have transcripts, and we have the referral orders, which gives us the questions that the court is going to consider. So we know exactly how many seconds has been spent in court, and as opposed to every other case in the High Court or even in the District Court, and mostly in the District Court, the time spent in the sense, when you look at, say, a schedule for a case and you know that these many dates a case was listed, when it comes to constitution bench, you know that that equals the time spent in court, right? Nothing else happens. On the other hand, if a civil suit has spent 15 days in court, you don't really know what has happened. But when it comes to constitution bench, and it is a rarity that a constitution bench is taken up, because there are 5 judges sitting over there, it is extremely rare that you go up there and nothing happens, right? So you equate the hearing date to actual judicial time spent. Hence, starting with constitution bench cases becomes easier as far as designing a DCM framework is concerned. And the second bit is judicial time. Why we chose to do constitution bench cases is because stakes involved, right? At any given point in time, you have to multiply the judicial time spent into at least 5 times, because that is the composition, that is the strength of a constitution bench. Just in terms of data, in the last 6 months, there have been 59 constitution bench hearings in 18 cases. Now, as far as those individual lawyers and litigants are concerned, those are 59 hearings. But as far as the court is concerned, that is 800 judge hours spent on these 18 cases, while we know that there are 75,000 cases pending in Supreme Court alone. Hence, the importance of having to streamline and having to predetermine how much time the court ought to spend on these matters. And again, I want to caveat, because every time I write about this is the question that is asked. But constitution bench matters are so important. Because they are so important, you need to ensure that the court has continuous capacity to constitute those benches, 5 judges at a time. I think during Justice Ramana's time 2 years ago, no constitution bench got constituted, not because the cases pending back then were not important, but because the court simply did not have the avenue of pulling away 5 judges in one go from various other matters. Hence, the need to make this a lot more scientific in approach, and also to know how much to actually allocate. If the court can plan around it, then we will in fact ensure that CB matters are taken up. The third reason why we took up constitution bench matters is also because, thankfully, the Supreme Court has already taken baby steps in this direction. And what is that? Since Justice Lalit's time, UU Lalit's time last year, timelines are being prescribed for hearings in constitution bench matters, and this is extremely rare at any level in Indian judiciary, because again, we go back to our painful heritage of having adversarial system, of having the common law system where oral submissions are glorified, right? So it is very difficult for us to move away from that tradition. In fact, there was a law commission report wherein they abandoned the exercise of prescribing time limits, because it was like multiple stakeholders were invited to discussions where the opinion was that it is appalling that we are even considering limiting oral arguments. But of course, we have traveled some distance from there, and now the Supreme Court has taken steps towards limiting oral arguments in starting with constitution bench matters. However, what we see, and the graph here shows our calculation for 4 cases. And here I must mention that all the data and the assessment that you see here has been painfully collated by my colleague Jyotika, who is the co-author on these papers. She keeps track of all constitution bench hearings like a hawk. So she is the one who has calculated the seconds and minutes that have been taken up in these cases. So as you can see, the court has allocated time. And the problem here is the manner in which the allocation is done is also ad hoc. Sometimes it is communicated at the start of a hearing that this is how much time you will take, this is how much time the rest of the lawyers will take. Now, more recently, in the ongoing case on Article 370, thankfully this has been a little more systematic, where the nodal advocate who has been appointed for both the petitioners and the respondent side has to bring the lawyers on each of the sides together to then allocate time for each side, which is then communicated to the court. So to that extent, it is a little more systematic, but we don't really know what the equations over there are. What are the considerations based on which time is allocated? I'm not sure complexity of the case or the questions that the councils are dealing with actually plays a very definitive role in the time that is allocated, right? So as you can see, allocated time is often being breached. The actual time that is taken is significantly more than what is allocated. Now the conclusion that we can draw from this is either that the lawyers do not want to adhere to these timelines because, or cannot adhere to these timelines because they are unscientific to begin with, or it is that the lawyers are taking more time than necessary. Either which way, we have to solve for this problem. Now, zooming in a little more in terms of how the individual advocates are taking time, and this is where I think the arbitrariness increases, because what the court seems to be doing is that the intent is right, which is that they want to limit the arguments. They don't want to give a free rein to the advocates. But as I said, it is at the start of the presentation. It is at the start of the advocate beginning with their submissions that the court says this is how much time you will be given, right? So they don't really have much of a leeway in tailoring their arguments to actually stick to the time limits. And oftentimes, some of the advocates are given time limits, some of the advocates are not even given time limits, right? So it is fairly ad hoc that way. So even at an individual advocate level, it makes sense for us to solve for this problem. Now, I know the slide is a little cluttered. I wouldn't want to go through each and every instance here, but to look at what other jurisdictions are doing, especially apex courts in other jurisdictions, how they are managing their time. And as you can see, all of them have prescribed an upper limit. Some of them are an outer time limit, which is compulsorily followed in all the cases. A few others have gone on to curate based on multiple parameters. And here I would like to highlight one jurisdiction in particular, which is the system followed in Norwegian Supreme Court. They fix time on a case-to-case basis. And the deciding authority for this is the Appeals Selection Committee. A judge in the Appeal Selections Committee identifies what the complexity of a case is and accordingly allocates time. Unfortunately, however, they haven't publicly identified what goes into deciding complexity, but they have been following this for a significant amount of time, which has given way for researchers to analyze cases and sort of re-engineer what those complexity factors may have been. There is a beautiful research paper where around 1,400 judgments, 1,400 cases have been analyzed to look at what are the various complexity determining factors that this appeal selection committee may be looking at. But this also shows us that the Supreme Court of India, and hopefully later on other courts as well, they have to start somewhere. In the sense you cannot have a predetermined framework of 1 to 10 criteria which you will start and end with. You have to start now, uh, almost second guessing that these are the factors that will play a role in the time that ought to be allocated by the court. And once you have a certain set of cases to see if that actually played out, because you, along with giving that outer time limit, you will also give flexibility, right? That is the only way you can make it fair, because nothing right now is set in stone or scientific per se. So you start with certain set of criteria, and then after some point you analyze, is this working or not working, and then you tweak the system. That is the approach that the Supreme Court can actually follow, but there seems to be some resistance in taking that path of identifying the factors that will determine complexity. Which one, sorry? No, this is per case. Supreme Court of United States allocates 30 minutes per side. And this is very strictly followed. Only in, I think, Bush versus Gore, they deviated from it, and that was a big enough case for them to make an exception. And as you can see, Supreme Court of United Kingdom, 2 days and only 2 attorneys. While here, as you will be seeing in live stream cases, it is as in it is about FaceTime in court, right? With live streaming, I think that need to be seen has only increased. So there is no outer limit of any kind, the number of advocates or the time taken by each advocate or the time taken by the side in all, which is scientifically currently determined. So in working paper 1, while until now I'm talking about the time allocated that needs to be arrived at scientifically, I will now shift gears and move towards what are the potential complexity factors. And here again, as I said, it needn't be something that we start and end with. This is our attempt, and as you will see, it is based on very basic understanding of the system, entirely driven by first principles. We have taken a crack at arriving at a formula to determine the complexity factor and thereby the time that ought to be allocated for constitution bench matters. Our starting point was a sample set of 5-judge bench cases in the Supreme Court. We calculated the number of hearings that these cases took and the number of advocates who appeared on each, the number of advocates that appeared in all for that case, divided the two and arrived at a value. An average of that is what we call a good advocate ratio, which tells us that an advocate shouldn't take more than 0.45 hearings, ideally. And by hearings, we are roughly looking at around 3.5 hours of submission in court. Now, the second step is determining complexity score. Here we are looking at number of issues involved. Now, again, this is the advantage of looking at just constitution bench matters. Here the issues are clearly identified. There is a referral order where the questions of law under consideration are laid out. So you know what the issues are, you know the laws that are involved, and you also know the precedents that are in conflict. We accordingly determine the complexity score and segregate the cases into 3 tracks: hard, intermediate, and standard. Now, to make the number wieldy, we have a complexity coefficient. And overall, the formula you have is for you to determine the number of hearings a case will take in the Supreme Court. You multiply good advocate ratio into number of advocates appearing in the case with a complexity coefficient for the case. We applied this to the Maharashtra Assembly case. The number of hearings that the formula gives us is 7.2 hearings. In the court, however, only 5 hearings were allocated, which, as we saw, was breached at individual advocates level as well as for the entire case, and they ended up taking 8.57 hearings. Now, our submission is that if you scientifically arrive at a value, you then go on to have a case scheduling conference, and this is where the Norwegian system comes into picture. We take some processes from there to, one, identify a nodal officer from the advocate side, have a judge sitting from the bench who will together arrive at what an ideal number of hearings for the case ought to be. And then you record that in the order sheet, because that is the only way we have come together. The advocates will actually stick to it. Um, so once we do that, it you still give leeway with the bench to alter that on the go. Um, and again, given that this is going to be a work in progress for a few cases, for a few hearings, the court needs to enter into it with an experimentative mindset. That is the only way it will work. Now, of course, that's a tall order. How to convince the bench to now get into that mode, how to bring the lawyers to enter this framework is going to be a huge challenge, but a start needs to be made. So this is the work that we have done so far. Happy to take questions. I don't know how well I'll be able to answer, because as I said, this is all currently something that we are thinking about. So I would like to use this forum to actually seek feedback and perhaps also some fresh ideas in terms of how we can take this to courts. We have also started working with one high court where a pilot is currently ongoing. So we will publish the findings from that pilot as part of the working series. But how to take this to the Supreme Court or some district court, that those ideas are more than welcome. Thank you.